Hi everyone, my name is Joshua Suarez. This presentation is for CGS 3095, Technology in the Global Arena, and I will be speaking of intellectual property in tech. Intellectual property can be viewed in multiple angles as a positive instrument that encourages and promotes authenticity and innovation, or as a strategy that orchestrates monopolies in our country. In this paper, we highlight what intellectual property is, how it works, or its intention, and multiple points of view regarding the subject matter. Intellectual property is an area of law that is put in place in order to protect the rights of creators and their original work. According to the World Intellectual Property Organization, which is a United Nations agency considered the global forum for intellectual property services and informations, defines intellectual property as a reference to creations of the mind, encompassing inventions of any type, such as literature, art, symbols, names, software, etc. Intellectual property is a general idea that is supported by sub-laws, which are patents, copyrights, and trademark laws. Protection laws such as patents or copyrights are limited in time. They are only handed out for a certain period of time, which is normally 20 years. Patent laws are enforceable only in the country that they were issued, unless a global patent was issued. In order to be granted a patent, there are certain requirements. The first being that the patent law specifies that the subject matter must be useful. The term useful in this connection refers to the condition that the subject matter has a useful purpose and also includes operativeness. That is, a machine which will not operate to perform the intended purpose would not be called useful, and therefore would not be granted a patent. A patent cannot be obtained upon a mere idea or suggestion. The patent is granted upon the new machine, manufacturer, etc., and has been said, and not upon the idea or suggestion of the new machine. A complete description of the actual machine or other subject matter for which a patent is sought for is required. Some people confuse patents, copyrights, and trademarks. Although there may be some similarities among these kinds of intellectual property protection, they are different and serve different purposes. We first define what patent is. A patent for an invention is the grant of a property right to the inventor, issued by the United States Patent and Trademark Office. Generally, the term of a new patent is 20 years, from the date on which the application for the patent was filed in the United States, or in special cases, from the date an earlier related application was filed. U.S. patent grants are effective only within the United States, U.S. territories, and U.S. possessions. Under certain circumstances, patent term extensions or adjustments may be available. The right conferred by the patent grant is in the language of the statute and of the grant itself. The right to exclude others from making, using, offering for sale, or selling the invention in the United States, or importing the invention into the United States. What is granted is not the right to make, use, offer for sale, sell, or import, or the right to exclude others from making, using, offering for sale, selling, or importing the invention. Once a patent is issued, the patentee must enforce the patent without aid of the U.S. Patent Trademark Office. There are three types of patent. The first being utility patents, which may be granted to anyone who invents or discovers any new and useful process, machine, article of manufacture, or composition of matter, or any new and useful improvements thereof. The second is design patents, which may be granted to anyone who invents a new, original, and ornamental design for an article of manufacture. And plant patents may be granted to anyone who invents or discovers and asexually reproduces any distinct and new variety of plant. Copyright is a form of protection provided to the authors of original works of authorship, including literary, dramatic, musical, artistic, and certain other intellectual works, both published and unpublished. The 1976 Copyright Act generally gives the owner of copyright the exclusive right to reproduce the copyrighted work, to prepare derivative works, to distribute copies, or to distribute copies of the copyrighted work, to perform the copyrighted work publicly, or to display the copyrighted work publicly. The copyright protects the form of expression rather than the subject matter of the writing. For example, a description of a machine could be copyrighted, but this would only prevent others from copying the description. It would not prevent others from writing a description of their own or from making and using the machine. Copyrights are registered by the Copyright Office of the Library of Congress. A trademark is a word, name, symbol, or device that is used in trade with goods to indicate the source of the goods and to distinguish them from the goods of others. Trademark rights may be used to prevent others from using a confusingly similar mark, but not to prevent others from making the same goods or from selling the same goods or services under a clearly different mark. So why mention all this? Well, having mentioned all of the above, one might assume that this legal protection for creators and inventors is straightforward and that it doesn't contain any flaws. Besides, it has been clearly mentioned in multiple articles and well-documented documentation regarding intellectual property that its purpose is to promote innovation and encourage economic growth. However, we have many issues and loopholes that have emerged within this area of intellectual property legal protection. An example would be patent trolls, who have strategized forms of tricking the sole purpose of intellectual property protection by establishing patents for non-existing products or ideas, and for products of which absolutely no contribution was made. Patent trolls are companies that obtain the rights to one or more patents in order to profit by means of licensing or litigation, rather than by producing its own goods or services. These patent trolls exist normally as companies and collect portfolios of patents, who do not produce or create the technologies described in the patents, and who then later take legal action upon upcoming startups and creators who intend to release the new products to market. Patent trolls have caused some damage in the tech industry, and it is only expected to become worse as time passes. According to Lot Network, which is a patent protection company, 84% of all high-tech patent lawsuits filed annually are filed by patent trolls. Additionally, more than 10,000 companies that have been victim of patent troll lawsuits, at least once in their company lifetime, and 50% of those companies that have been victim of issue have had less than $10 million in revenue yearly, therefore causing businesses to close or allowing for them to barely stay alive, which basically down the road would lead them to have to declare bankruptcy and not survive it. Patent requirements for patent creations in the United States and issued by the United States Patent and Trademark Office state that the subject matter must be useful, meaning that the subject matter has a useful purpose and is operative. A patent cannot be obtained for an idea or suggestion, and a complete description of the actual working product is fully required. However, patent trolls have maneuvered their way through loopholes in the system by issuing patents outside of the US that can cover legal scope of any product developed worldwide. The purpose of this presentation is to inform listeners of what intellectual property is and how it actually works. Intellectual property has its purpose, as stated in the beginning of this presentation, and in many forms of the documentation regarding the subject, and it is to promote innovation and economic growth. However, with this presentation, I present many examples of how it has somewhat caused a reverse effect, and how many have found unethical ways of manipulating the system to their advantage. Again, my name is Joshua Suarez, and I thank you for your attention.